Hey everyone, I'm Tristan Ritchie, and I'm here with another episode of the Real Estate Podcast on Love the North. And today I have a special guest, a friend, my lawyer, Spencer Moore. Welcome.
Nice to meet you. Thanks for having me. Before we jump into it, I'll do my standard disclaimer here. This isn't legal advice. This is a general discussion. If you need something specific or tailored to your situation, give me a call.
Perfect. He wanted to really make sure he hammered that home before starting. So we're going to focus on, you're one of the biggest real estate lawyers in Sudbury. So we wanted just to do a quick question and answer period about what you do, what your involvement is in the real estate transaction, and kind of the back end stuff that you do. So once someone gets an accepted offer, firm offer is usually when they contact you, right?
Correct. Yes. So usually steps 1 through 5, I'll say, are with your agent. Once it's firmed up, the paperwork comes to us from your agent directly. From there, we get started. So the quick and simple version is we're usually going to reach out either via phone or email. We're going to send you an intake form. Once you complete that intake form, we consider ourselves retained. We do everything we have to do on our end from there.
Perfect. So what's kind of that stuff that you do on your end? So I know in our APS, Agreement of Purchase and Sale, we have a section that says basically a whole page of what your job description is, the title search. You kind of want to explain what the title search, what are you looking for when you're looking at the title of the property, and what should they expect? Like clear title?
Yeah, so clear title is tough to define, and I'll say it's a bit of a myth. So clear title in Sudbury sort of includes some of our standard easements. We often see bell easements, hydro easements, sewer easements, a lot of smoke easements in favor of our mines here, given that we are a mining community, one of the joys of the North. So that would be things that we would often find in your title search and we aren't overly concerned about. Now, things we are concerned about, things we are looking for in your title search would be liens, encumbrances, mortgages that shouldn't be on there.
So what's a lien and encumbrance? Like just a quick version.
Yeah, so quickest and simplest thing to think of for a lien, a common example is a piece of rental equipment. So I don't necessarily want to name drop anyone, but Reliance. We see a ton of Reliance liens. We call those NOSIs, or Notices of Security Interest. Those actually became illegal very recently. We are now taking care of, when I say we, me and other lawyers, discharging those as the properties come before us. In terms of an encumbrance, most common would be an old mortgage. So if there's an old mortgage registered on title, we're going to have to get that taken care of before the purchaser takes ownership.
Yeah, so the purchaser, you don't have to worry about having to assume any of these on closing, and that's what you're looking for.
Exactly. So those are things we're looking to take care of, whereas what I mentioned before, there are certain easements like smoke easements, hydro, sewer, those we'll often find in favor of Bell, in favor of the city of Sudbury. Those are ones we have to use our discretion. Generally, they're standard, and generally they actually can't be discharged. They need to be there so that Bell, hydro, the city can service utilities or service lines to the property.
So you just leave those. Those are typical, yeah. So then that's the title. And then you're also, everyone's heard of someone who's run into a building permit. Open, non-existent, on closing. So what I know that's one of the things that's come up a lot more often now. During COVID, everyone was like, I don't care. This deck has no building permit. I just want the house. Now it's getting a little bit slower. You're seeing that come up more?
Yes, more and more. It seems like every second deal these days has a permit issue.
We're on the phone all the time about
it. Yes, I will give us some grace here. We are a northern community. We are blue collar. A lot of people, everyone and their brother and their neighbor likes to do unpermitted work. So half of the houses we see have an unpermitted garage and an unpermitted shed and an unpermitted deck and an unpermitted pool. So unpermitted work is often what we call caveat emptor or buyer beware. We do still try to sort of vet for that. If you do not catch it before closing and we close the deal, it now becomes your issue. But unpermitted work is very common. It doesn't mean it's done wrong. It means it hasn't gone through the proper process with the city to be issued a permit. What we're really concerned with as a lawyer is open incomplete permits.
Yes, that's because then you have to complete them, right? Then that's where the can of worms could be open, right? They started 10 years ago, building code changed. Maybe it was done right before, but now you have to do a whole bunch of work. What we see often, like what I recommend to clients is it a deck? Smaller deck, usually not a big issue, no permit. You can let that go, right? If it's a big adding 2 bedrooms to your house with a foundation, that you want to make sure has a permit or a closed permit at least, so that you're not worried about having to redo, or that could be a big expense, right?
Yes, exactly. So building on that a bit, I will say, as the lawyer, we don't get to walk around your property. If you know there was recent renovations done of a sort of substantial nature that would likely require a permit, tell us. If you tell us beforehand, we can do the sort of necessary due diligence to talk to the other side and figure out what's going on. What we find in our searches is not unpermitted work. There is no registry or database to show us unpermitted work. By its very nature, it was done without records. What we find is the city's permit records, which most commonly will show us pulled permits with a completion date, or pulled permits, in the worst case, without a completion date. When we see that, that's when we know there's an issue that might fall onto you after closing, because again, if you close with an open permit, you're now responsible for that. Whether that's closing it down the road, or worst case, the city coming and issuing an order to comply to deal with it.
And we often, Spencer has to work hard on these files, but we often get it done, right? It gets closed or something gets figured out. Sometimes the seller doesn't even know they have this open permit. That's happened to me several times. Or no permit, right? Another thing that we see often, or that we put in contracts, or you often see with the state sales, is as is. We got screwed with one recently. Yes. I won't go into detail, but so as is put. Usually people automatically think red flag, as is. They're just trying to hold liability from themselves, which they are. But what does as is usually protect?
Ooh, this is a big term. So, as is clauses in agreements of purchase and sale are a legal gray area. And when I say that, I'm telling you that we're a common law system here in Ontario and Canada, meaning our case law and our law develops over time as judges make decisions. With regards to as-is clauses, there is a string of case law on both sides. There is case law to suggest that as-is clauses apply only to sort of the structure itself and what is sort of known and disclosed, and there's a string that suggests as-is clauses apply to everything. What I can say when we speak to that is the best sort of safety measure on your part when entering into an agreement, if there's an as-is clause, make sure it's very clear in layman's terms what it includes and what it doesn't include. It can protect a seller from liability, but as we have seen in cases, there are times where even a buyer agrees to an as-is clause, they didn't realize that it included everything, and they don't show up on the day of closing with money. And as lawyers, there's nothing we can do to make someone show up with that check.
That's super true.
Yes.
Unfortunately. So the as-is is very blanket statement, gray area, like you said. So as-is basis, talk to your agent when you're going through the house and what we think that possibly the reason for it. Again, it's not always hiding something. It's usually protecting someone who's selling their grandparents' house and they've never lived there, so they don't know what has been going on in the home for the last 20, 30 years. So then now the money part of it, I guess you have to pay for a house. You manage the money, you got trust accounts, all that. So they send a deposit. It gets held usually in our trust account. And then how much money, when do they owe you the down payment, and how do the sellers get their money from you?
Yes, very good question. One that I wish more clients knew before they started the process. So all of the money is generally handled by us. When I say that, what I mean is the down payment, the payment for all of your searches, all of your disbursements, everything else runs through us as the lawyer. Generally, you have to have that money available and in your account, I would say, as a rule of thumb, 2 to 4 days before closing. Every lawyer is a little different. I try to get my clients in to sign with me 2 to 4 days before closing, meaning I need you to bring in that money via bank draft during that signing meeting.
That money being just the down payment and your fees.
That includes the down payment. So whether it's 5%, 10% through your bank. Now, I will add a caveat there. The amount is always a little bit higher than you expect, because if you have any mortgage default insurance, you're also paying the PST on that upfront. So you have your down payment amount, your legal fees, your title search, your property search, all other legal disbursements, plus your HST and land transfer tax on that. All of that goes through us, and you bring that in for the signing meeting.
So you get the whole, the one pager. What's that called again?
So different lawyers have different vernacular. We use the term fund summary. So we break it down in a fund summary. We usually send it to you about a week before. That will outline all of the expenses and the exact amount you need to bring into us, exactly who you need to make the bank draft out to. It's very important that it's a bank draft and not an uncertified check so that it clears instantly into our account. We also send you what's called a statement of adjustments. That's where all the credits and the debits on the file are done. So you generally get a credit for your deposit already made. The seller gets a credit for the purchase price, and then generally one or the other side will have a credit for the property taxes paid up thus far for the year, because we calculate it down to the day.
Perfect. What's the most common, oh shit, I had to pay for that thing that comes up? They're like, oh, I wasn't expecting this.
The biggest and scariest, but often they do know about it, they just don't know how much, is land transfer tax. So if you are a first-time home buyer, there is this
rebate.
Yes, but I was going to say there's this misconception that you get the full amount off. It's actually capped at $4,000. That $4,000 caps out around a $360,000 purchase price. Once your purchase price is beyond that, you will have to pay the excess land transfer tax. I often see first-time homebuyers come in, buying a house at $450,000, thinking they have no land transfer tax, and then being shocked when they find out that they owe $1,000, $2,000, $3,000 on top of their bill for land transfer tax.
Okay, maybe I should make a one pager that warn people about that.
Yeah,
we discuss it, but they always forget. Okay, that's really good to know. So then you bring the check in, and then you do the transfer. And as a seller, you're giving them the whole payout amount couple days after closing, I'm assuming, or a day after closing.
Yes. So every lawyer and law firm is a little different on how they do their payouts. Some of the old-fashioned lawyers like to actually hand you a check or mail you a check. I do most of my payouts via wire or EFT. Now, there's pros and cons to that. The pro is it's not held by your bank, so you avoid, at least in today's climate, the 5-day hold that banks have. The downside is once it's gone into the ether of the bank, I can't control it. So once we send the EFT or the wire, could take 1 day, could take 3 days. There's nothing I can do to pursue or follow up on it. So that's how we do our payouts. On a sale, we are responsible for paying out all of your debts before we can actually give money back to you. So if there's a mortgage, we have to pay out that. For agents, we pay out their commission. If there's anything else, for example, a bridge loan or property taxes, we pay out that. And then the equity or the excess is released back to you, usually via EFT directly to your account when I do it.
You guys are doing a lot for your fee.
Yeah, so you work for it.
Yeah, especially the troubled files. Those end up being a lot of work. But well, that's pretty much it for today. I just wanted to kind of go through what Spencer does or a lawyer does on the back end of things, why they're getting paid, and when their value is really, really strong when you do have to come to negotiating after the fact that it's already sold, right? When things come up. So I know certain files were on the phone a ton, and I'm sure with the clients as well, and you're always really appreciated. You're probably the most responsive lawyer that I've dealt with, so that's a huge bonus, especially when there's a troubled file. And thanks for coming in today.
Thank you for having me, and thank you for the kind words. I appreciate it.
Well, thanks everyone for listening. Another episode of Love the North, the real estate podcast, and looking forward to seeing you guys in the next one.